Hi, this is Sean with Platinum Audits. I'm going over a video presentation today and adding my commentary in the hopes that we can educate and explain things a little more detailed on how certain things in the industry have evolved with these reports. Now, this was a presentation given in a seminar some time ago. And basically, this gentleman is going over a report. I will play the presentation and I will add my commentary. And I hope you gain value and education from it and learn about these securitization audit reports and some of the different technical aspects that relate to the securitization audit reports. I myself have been at the recording of this video, have been in this industry almost 15 years. I actually started in finance in 2006, and I've been in this industry for a very long time. And I love to share my knowledge, and I hope that this commentary will help you learn and help you in understanding these reports in a more proficient way. Just a disclaimer, my name is Sean, and I am simply adding my commentary to this video. This video is for educational and entertainment purposes. Thank you.
Right now, I'd like to go over our level 3 Bloomberg report with you. It's going to go over quite a bit from an attorney standpoint. So if you guys are looking to go and litigate a case, then this is definitely the product that you guys are going to want to take as evidence. All of our reports are going to come out of the and it's going to be prepared for the homeowner that you have that is going into foreclosure. As we go through the pages, what you'll see are the different parties that are involved in the transaction. Obviously, the borrower and the co-borrower, their address that is actually in foreclosure. The transaction participants are going to represent everybody that was present at the time of closing. The mortgage broker, the servicer who the homeowner eventually ended up making their payments to. The nominee or beneficiary is typically going to be MERS. Not 100% of the time, but most of the time you will see MERS named as the nominee beneficiary of the loan. The original mortgage lender, whoever actually lent the money to the homeowner to purchase the home. The mortgage trustee and the title company are typically associated. And obviously those are the people who drew up all of the closing paperwork for your homeowner to actually acquire this loan. Now the first page.
Now you're going to see MERS and a lot of the loan documents nowadays. MERS, the Mortgage Electronic Registration System. You're going to see that if you are a consumer watching this video, you can actually, if you have a MERS or a MIN number on your documents, you can actually go and check that on the MERS public database and see if it's active or inactive. It's interesting to see that when you actually can check that online. So that's one of the things that he did mention, and that's one of the things that's mentioned in the reports. Those reports are basically mentioned, and if there's MERS on there, then that's going to be mentioned on the reports, right? Because that's part of the loan documentation.
You guys are going to look at when you are completing your complaint is going to be the securitization participant screen, which is going to give you all the named parties of interest that you're going to highlight on your complaint.
Now, name parties and interests, that's important. You might want to take a note of that, right? So name parties and interests basically is going to be the securitization participants page of the particular report, right? So that's a very important part of the report, okay, that's showing the securitization participants. So that's going to be the originator, the sponsor, the depositor, as he's going to explain. These are very important aspects of back-end research. So when a client or a homeowner, whether you're a homeowner or if you're an attorney or lawyer watching this video, one of the important aspects of obtaining a report is basically trying to uncover the back-end participants, right? That's going to be the people, the companies and the institutions on the back end. And that's one of the important aspects of the report because that reveals that information to you. So the depositor, the underwriter, the trustee, in some cases, the indentured trustee, there's a lot of talk about that as well, who's the indentured trustee, but that's one of the important aspects of the report.
The original lender, the sponsor, the depositor, and the issuing entity. These four components here will make up what a proper chain of title should be. So once we go to the chain of title page, you'll be able to see if the loan traveled through a proper chain of title. The trustee acts on behalf.
Now, chain of title is one of those terms that can be used in multiple ways. in my opinion. And different companies have different ways of explaining it. However, this is a good explanation. Chain of title, as far as showing you the securitization participants. Right here are the participants, and the chain of title as far as the daisy chain of all the individuals involved, right? The depositor, the trustee, who issued it, where did it go, where was it funded, when was it closed, who was the trustee, who was the indentured trustee, okay? Then there's going to be front end chain of title, okay? Front end chain of title when you're looking at a property, and the property has a loan, right? And that loan basically was changed to another servicer or switched to another servicer multiple times. The servicer changed, or it was sold to another bank. Maybe it was sold to 2 or 3 banks. So that's front end chain of title. Okay. Front end chain of title, back end chain of title. And then you have, those that say, well, in some of the older verbiage, before some of these companies were started, we started to get popular in our industry of securitization audits. You have the old guard, as I call it, that say, well, chain of title is actually, when a person looks up a title profile, a title lookup, right? A title search on a property. Well, you have a purchase, a refinance, a refinance, a refinance, purchase. That's going to be an overall chain of title, right? That's something like, for example, an investor would look at, or a real estate agent will look at a history of a property, right? So that's historical chain of title. So keep in mind when you're watching that there's different ways you could use the word chain of title. That's my point. However, it's not to say that any of those are wrong. It's just that term chain of title can be used multidimensionally and multilaterally. That's the point.
The issuing entity, because they are nothing more than a pass. They don't have anybody to collect payments, which obviously is the job of the servicer, and they don't have anybody to conduct clerical things or administrative tasks, which is typically reported to the trustee. Now, the custodian is in charge of handling all of the paperwork, the notes, deeds of trust, or mortgage if they actually make it into the trust. The important pieces of this page that you're looking at as well are going to be the cutoff and the closing date. Now, the prospectus will outline what the cutoff and closing date are for this particular trust. And that's important to you because if you're looking at an assignment of mortgage or an assignment of deed of trust or an assignment of the note, and it does not make it into the trust within this cutoff and closing date time frame, which is typically 25 to 31 days, that's a pretty big problem for the trust at that point.
So what he's talking about is the cutoff and the closing dates. Okay. So basically, you have a closing date on the trust. Okay. So technically, the securitization trust in their own prospectus says, okay, the closing date is today. So that means, or next week. So that means that there has to be with a 25 to 30-day window for the loan to get in there before the closing date. Okay. Now, I've seen files in my career where, and he mentioned the assignment. Okay, the assignment of mortgage document is a document filed when they sell the loan. Okay. When they sell that loan or they transfer it or there's some adjustment to it, like, okay, they add MERS on there or they're transferring it to another bank, they'll file the assignment of mortgage document at the county recorder's office. The homeowner is not notified unless you, as a homeowner or the attorney, goes and actually pulls a title report, and you'll see it on there and you can pull the document, right? So I've seen files where the assignment is filed at the county years later after the closing date or the cutoff date. So according to the prospectus, okay, like here you'll see 2019, right? Or 2024. Okay, it has to be in there before January, let's say January 2024. Okay. So they file the assignment years later. So this is where you have this question of what's happening here in the securitization process. Is this proper? Is this properly done? See, that's the question. That's why the report is so important. That's why, obtaining this information and having an expert auditing team have this analysis is important. I mean, these are things that add up to, okay, what are we doing here? And how are we, like, for example, an attorney, how are we going to, as an attorney, how is the attorney going to write his case, right? These are all little things that add up. So just keep that in mind. So cutoff and closing date is very important.
Basically, once the cutoff date begins, they are allowed to actually put loans into the trust. And once the closing date occurs, there is absolutely no more notes that can be placed into the trust. Typically, depending on the pooling and servicing agreement, they will be given a 30 to 90-day right to cure, meaning if there's anything that that needs to be finalized with any of the loans that they have in the trust, they have a 30 to 90-day time frame to do so. As we continue through the report, you will see on every CFLA report a copy of the prospectus and the pooling and servicing agreement. Now, the prospectus has specific language in it that cites that the note and the deed or mortgage have to travel as one unit throughout the debt conveyance process. This is one of the tools that you're going to use when you build your complaint, because it's going to outline that specific fact that the note and deed have to be congruent as one unit throughout the conveyance process. It's also going to give you a list.
One of those, that's a great thing you mentioned there. One of the cases you might want to look up. It's an older case, but it was Glaske versus Bank of America. That was one of the cases where they determined that the note and the deed have to be together at the time of foreclosure. That case was overturned, but it's one of those things where you can read up and see what was actually ruled in that particular case. And that's one of the things where that's one of the arguments used, one of the general arguments used, where it's like, okay, prove the note, prove you have the documentation, which is also another branch of chain of title. Okay, if you don't have proper chain of title, if you don't have proper documentation, well, you know, even if the ruling was overturned, here's the thing. If there is some type of action or foreclosure filed on a property, right? Well, there's still procedures that need to be followed, correct? So chain of title is one of those arguments that could branch off into that area and say, well, look, you don't have, like, for example, if they don't have proper chain of title, if they don't have a proper documentation that proves that they own the note or proves that they own the documentation, just to say, look, we can foreclose on this property, right? Well, then everybody would be foreclosing on each other, right? I mean, this is the point here. It just goes back to just common sense, right? So that argument can be branched off into multiple directions, you know, as my point earlier. So chain of title, and that's one of the things I like to talk about. You know, I mean, there are literally actually, you know, you could order just a chain of title audit on a mortgage, on a loan, on a property. So, you know, obviously this report is going to be more in depth in securitization, but there's different levels and tiers, right? But that's one of the arguments, right? It's like, okay, you are trying to foreclose on this property, you know, Mr. Financial Company. Okay, well, perhaps it is a good idea procedurally to prove chain of title that you own it, and that's the arguments people use. You see, that's how where they get them on, and these are the counteracting arguments that give the opening for the homeowner and the consumer. And that's why the reports are so important. The reports, either reports, whether you get a low level, where you get a high level report, there's different types of reports, right, in our industry. However, you know, they're all important in their own way.
List of all the named parties and interests that were on the previous page. And what we'll do is excerpt the language that is important to you as an attorney, and then provide you with the link to the SEC website where the prospectus was pulled. Now, this is important because the prospectus being about 395 to 450 pages long, obviously we're not going to include that in.
Yeah, so that's basically he's saying that the prospectus link is going to be in the report, so you can go click it, because the prospectus or the pooling and service agreement is going to be a 300, 400 page document. So, you know, we don't attach, those are not attached to the document, because, you know, sending that via email is a very large document, right? So there's a link to it where you can actually click on and go download the pooling and service agreement or the prospectus. You know, as a homeowner or as an attorney, that's going to be important, right? Because then you can have that, you know, if you need something, information from there as well. However, the important excerpts from those pooling and service agreements and those prospectus are going to be in the report. And that's why, you know, the auditing team is so important to have an expert auditing team that's going to go through and give you those important excerpts from the pooling and service agreement or the prospectus. And that's why it's important to get an audit done, because you have that team, 20 years combined experience, you know, that has those eyes. It's like going to a high-end mechanic, right, that just knows certain things about the parts and about the cars. He just knows. And then that's one of the things that is important, to have a good team, good auditing team looking at your file.
Higher in the report. So the judge can go to the SEC website and verify that this language came directly from the prospectus that correlates to the trust that we have named on the report. Now, the pooling and servicing agreement has been referred to as the Bible for securitization. And the pooling and servicing agreement is the contract that the trust would have with the SEC that allows them to take a note and turn it into a mortgage-backed security, okay? This will outline all the roles of the originating lender, the sponsor, the depositor.
Nobody said that allows them to, okay? But are they doing it properly? Are they doing it within the procedures? Okay, are they doing it within the proper chain of title, within the proper assignments being followed, right? And is it filed properly? Okay, so that's where the audits come in. That's where the expert team comes in to uncover this information and give it to you in an analysis form that can be used.
The servicer, the trustee, and everybody involved in the securitization chain. So, what you need to look at, a couple of things is, does the servicer have the right to foreclose on the property if they are the holder in due course of the note? This also has to do with the debt conveyance process, section 2.01 and 2.02, which will always be highlighted in the report. We'll go over how the REMIC needs to come into existence. Typically, you'll see that a REMIC has to go through 2 true sales in order to become bankruptcy remote. So basically, it has to go from the originator to the sponsor, and there have to be recording fees and taxes paid there. Then it has to be recorded to the depositor, and again, recording fees and taxes will be paid upon that transaction. And eventually, it would make its way into the trust. Again, 2 true sales to give the REMIC its bankruptcy remote status. Without that status, the REMIC cannot exist, and the trust is liable for double taxation.
See, that's a very important note here, the REMIC and the double taxation, right? So basically a REMIC, the REMIC is a classification for a trust. So a securitization trust will have a REMIC tax status, okay? And I've seen files where this came up. So basically, if let's just say, for example, the name of the trust is, I have to use fictional names here. Securitization Trust Wonder Bank 34. This Wonder Bank 34 trust has a REMIC tax status. So in order to avoid the double taxation and by the processes he was mentioning, and in order for that trust to maintain a REMIC tax status, right? It's going to get tax breaks, right? Because it doesn't want to get double taxed, correct? And there's other things relating to this as well. It's a little further, but this is just a summarized version. So in order for that trust to maintain a REMIC tax status, they have to follow the procedures, right? The REMIC procedures, the proper procedures. Okay. Now I've seen a file where the homeowner's loan was securitized into a REMIC trust, and there was some procedural error that related to the REMIC tax status, that related to the REMIC keeping its tax status. So it violated some procedural error. I don't remember exactly what it was, but it came up on that file. Now, this was sent to the trust and the bank, and obviously this was something that was an important point being brought up. And obviously this was something that was, used in the favor of the homeowner because they don't want to lose their tax status. That trust, the Wonder Bank 34 trust, does not want to lose their REMIC tax status, okay? Because this is millions of dollars we're talking about here. This is a huge tax bracket. As you guys know, the taxation for large numbers. So I believe in that case, that particular point did help the client in whatever they were trying to pursue, obviously. However, just keep that in mind. So in order for them to maintain a REMIC tax status, they have to follow the procedures. And the REMIC procedures are its additional rules and procedures. And see, that's where my point was in the beginning. What are they doing? Are they following the procedures? Are they following the proper way of securitization of the procedures of the REMIC tax status? The procedures are very important. The procedures, the process, the way the assignments are filed. These are very important. These points have been brought up in cases. And what is really the point of, what is the main points of getting a securitization audit, a mortgage audit, really? Think about it. If I myself want to order a mortgage audit for myself, what am I really doing? The information in there, is valuable. It's important, as you see in this video. And I'm using that to put pressure on the other side to get some type of outcome that's going to benefit myself, correct? So regardless of how the information flows, regardless of the different aspects of the information, You want to go to an expert team, that has the best auditors in the country. And basically, those eyes on those reports are going to give you that best type of audit, right? That's going to give a person the best type of chance, in our opinion. So that's the case there. Using the report as a tool to put pressure on the other side to obtain some type of positive outcome, right? That's the one of the main goals.
Going back to the inception of trust. So, 2.01 and 2.02 are going to go over that language specifically to tell you what the conveyance process needs to look like for the loan debate from the originating lender into the trust. Again, this is another document that's going to be between 395 pages and 450 pages long. So the entire document obviously will not be included in the report. Again, what you'll see is the excerpted language that you need to go over that's going to help you build your complaint. And then you'll see the link at the very bottom. That way, again, it can be verified that it came directly from the SEC website. Now, the portion of the report that makes this a level 3 report or a Bloomberg report are the screenshots from what's called the Bloomberg terminal. Bloomberg is proprietary software that's used to track securities, whether it be coffee or gold or diamonds, or obviously in our business, mortgage-backed securities. Now, what you'll see on the first page is going to be the description of the trust and the highlight of the loan being in the trust specifically. The first thing that we're always going to look at is to see if there is a direct loan number match for your homeowner's loan. Typically, we will see a loan number match, then we can verify that the loan specifically is located within the trust by these factors here: the original loan amount, the origination date.
Now, this was they called it the loan find screen, LFND, as you can see at the top here. The company has changed this in recent times, but this was a very useful tool. Like I myself used to be a database researcher, so I would actually sit there and put input information and track mortgages myself. I actually would sit there for a good number of time and hours and just sit there and I saw a lot of interesting things, and that was in the beginning of my career in this industry. Actually, I really did enjoy it, but yeah, this screen actually is no longer there. This feature, it was like a feature that they had. However, there are other ways. This is not the only tool that the companies use. However, again, it just always goes back to having an expert team, because we also have our own internal data. We have our own internal notes as well. But this particular feature is no longer on this particular software. However, it's good to watch so you guys can see actually how, we call it loan tape, right? This is an example of a loan tape, showing the information of a loan, as it relates to a trust securities specific in a screenshot format, right? Keep in mind, even the large data companies, if you look at the bottom of their agreements and their, software programs, it says, data deemed reliable but not guaranteed. Okay. So when you hear talk of things online about, how do you find a trust or select a trust? Okay. Part of that is trade secrets. Okay. We have the best auditors in the country. Okay. We have the best team. I myself used to be a database researcher. Okay. There are things that I know about these things that, I could probably go and write a book on. Okay. We have the best team. We have professionals that talk in very technical lingo. Okay. These are people that have been doing it for 20 years, 15, 20, years, auditing and looking at prospectuses and trust and pooling and service agreements. Okay. There are other things within the prospectus that will show criteria of a loan, that will show you, okay, this particular criteria of a loan. However, looking at a criteria section of a prospectus or a pooling and service agreement, from an auditor's expertise, it's different from your common person looking at it. It's kind of like somebody looking at a high-end car and looking at a part, okay, and knowing, what that part, how it fits into the engine or the complements the engine. But just keep that in mind. Selecting the trust and doing research on trusts, have evolved over the years. Okay. When you have people going online and mentioning this, it's better that you go to the experts like ourselves and ask us how this is done. Obviously, part of that is trade secrets. However, it's a very complex process at times. It's very technical, okay, and it is recommended to use people that have expertise and experience and conducting these type of searches, okay. We also have connections to professionals as well that that we have in the industry. So data people and other types of people. So and we know how to look at the loan tape and compile the loan tape. So our set of eyes is different from just your common everyday person, or let's say a startup company. We've been at this a long time. I mean, I've been at this industry for 15 years. So when I look at a loan tape, I know what I'm looking at, and it's just one of those things, and that's why, when you look at our track record, you look at the track record of the companies, it's positive, it's good, and so one of those things, it's how do you use the report? So it's like we issue the reports, but it's how does the homeowner, how does the attorney use the reports? That's on them. So, but just keep that in mind that this is one of those things that you just have to consider.
Zip code and obviously the loan number being a direct match. Now, in the instance that there is not a direct loan number match, which does happen, typically the loan number can change once it gets to the servicing bank. The SEC website may have a different tracking number for it. The Bloomberg reporting software may have a different tracking number for it. So the loan is not going to always be a direct loan number match. The other factors that will be searched for would be, again, the original loan amount, the type of documentation that the loan was, whether it was a limited doc or a full documentation.
You see, so there he mentions it, sometimes the match is not a direct match. And what he means by that is the loan number, because back then you can actually, in the loan find screen, you can actually, I remember you can actually enter the person's loan number and then it will show you a match. But see, the thing is, the loan numbers change within the database. That's something that people don't know, okay? And that's something you might want to write down if you're taking notes in this video. The loan number changes. Okay, I've seen that myself when I was a database researcher and doing research on these trusts. So they changed the loan number. I know for those of you, I know in some instances when a servicer, when a person has a loan in one servicer and it changes to another, I believe in certain examples, they change the loan number as well, or they might add something to it. So keep that in mind as well. There's a record keeping factor involved here. Okay, record keeping factor. The loan numbers can change. Okay, when that happens, okay, the database researcher has to do a little more legwork. And again, search the criteria that's mentioned in the documentation of the prospectus and the pooling and service agreement. Okay, this is something that we do. That's why people come to us. Okay, and also looking at the loan tape direct from the database. Okay, this is very technical area of our companies. These are trade secrets. Okay, and this is why we are so successful at what we do. Okay, so it's very important that you listen to that part of what he said, because even back then, when this loan find feature screen was available, there still was instances where there was not a direct match, and then they'd have to do further legwork, as you see on the screen. And I apologize for the blurriness here, but you get an idea of what we as professionals have to go through to find the trust, how technical this is.
Loan, the geographic location of the property, whether or not it's owner occupied, the zip code, and then the city and state the home is located in. All those different loan characteristics will be searched to determine that your homeowner's loan is located within this trust.
The loan characteristics, that's another thing. The loan characteristics that are outlined, okay? Loan characteristics of a pooling and service agreement or the database, okay? So he's particularly looking at, this is in the database, he's in there, he's looking at it with the screenshot. I myself used to go through it. I used to go through a database that had thousands of loans, and I used to go through it manually. So I would search a person's loan in there, okay? And it will say in there, the city, the zip, it will say what type of loan it is. It will say origination, this loan amount, okay? And, again, without going too much into it, I'd have to take that information and then take it a step further, okay? And that is why I was a database researcher, okay? And I did that for some time there. And, honestly, I did enjoy it. I am a software engineer. My background is software engineering. And so, that's one of the things that I did do. So, for those of those that were talking about this particular item, the different discussions, I hope that this particular section does answer your questions as how the trust is researched and selected by the team for the audit report.
Now, a CUSIP number is something that's associated to all securities. It's basically an identifier that is used to track the security in question. Now, what you'll see is that each group will have its own CUSIP number, and each class will have its own CUSIP number. Also, each individual loan will have an individual CUSIP number that does not change throughout the reporting process. So we're able to identify exactly how many different classes or risk tranches the loan is located in based on the CUSIP number that's associated with the loan. This particular
one of the important items to take from that, he's talking about the CUSIP numbers. Okay, keep in mind there are different types of CUSIP numbers. Okay, he's saying there's multiples, right? There's going to be the ones that identify the trust. Okay, then the ones that identify where the loans are in. So, in my experience, when I was a database researcher, there was a master CUSIP. Okay, that identifies the securitization trust and the bond, right? That all the loans are in. There's a master CUSIP that, okay, this is the bond or this is the security and this is the CUSIP that's attached to that security or the bond. And then you have the minor CUSIPs, that is one of those loose terms used, the minor CUSIPs that are identifying different sections of a trust database that loans are in. So like, for example, I like to give the example of divided by 4, right? So let's say there's 100 loans. I mean, there's going to be more loans in there of this example, right? Thousands, but let's just say there's 100 loans in this trust called Wonder Bank 34 Trust, right? So they're going to divide it into 4 sections. So 100 divided by 4 is 25 loans in each section. So each section, those 4 sections, A, B, C, and D, will have its own CUSIP number. So basically, it's a record keeping, and it sometimes, like he said, could signify risk. So they might put like certain risky loans in the A section. They might put less riskier loans in the B section. They might put loans that are under 100,000 in the C section, and then they might put miscellaneous loans or maybe certain types of loans in the D section. So the CUSIP numbers identify each section. Okay, so remember, minor, master, minor, and other CUSIPs. So there's different types of CUSIPs out there. And one securitization trust can have multiple CUSIPs, one main one and the minors, okay?
loan will show that it's located in 19 different classes within this trust. Now, the 19 different classes that is separated or fractionalized into has to do with fractionalized banking. Basically, from a security standpoint, if the trust was going to have Moody's or Standard & Poor stamp a AAA or a AA or a single A credit rating on a group of assets, from a lending standpoint, you would think that only loans with a very high credit score, very low loan to value, and very low debt to income ratios would be stamped a AAA credit rating. Unfortunately, between the years of 2001 and 2007, the heyday of subprime loans, they needed to figure out a way to eliminate the risk of those subprime loans. So what they did was take the loans and break them up into fractions. Again, fractionalized banking. So they would take portions of the subprime loans and mix them in with other loans of better quality, and they would get Standard or Moody's to stamp it a AAA or AA or single A credit rated investment. Now, this shows implications of securities fraud and fraud to the investors because they were not selling a true credit rated investment. What they were selling was a blended credit rating. Now, what you'll also be able to see on this page is the number of classes or risk tranches that are paid off. So this loan is located in 19 different classes, and we can show that 13 of these classes have been paid. Now that means one of 2 things. One, that all of the certificates in that particular class have been purchased, or credit default swap has been issued. Another problem with the credit default swap insurance is that it's unlawful for somebody to take out multiple insurance policies on the same asset. You wouldn't be able to do that with your car note, just like they shouldn't be able to do it with a mortgage-backed security, because they're basically insuring at face value every single note in every single tranche that is located in. So this loan is essentially insured 19 times over the face value of the note. Now, what that means is that if credit default swap is issued in any one of these classes, that every loan in that class is paid at face value. So realistically, the trust stands to make 19 times over the face value of every single loan that's located in all these classes.
So you're saying that, they stand to make 19 times the value of the note. So think about that. All the notes in there, times 19, how many millions of dollars is that? So take your loan amount and times that by 19. And according to the presentation, that's how much money they're going to make on your loan.
So if you're looking at it from a negotiation standpoint, or once you get into discovery, which should be the ultimate goal in your litigation, is to get into discovery so you can lay your cards on the table. If you were going to go for some kind of a principal reduction, you show that 13 out of 19 classes have in essence been paid off, then you would want to use that as a simple fraction to negotiate a remaining balance and have a new note reissued to your homeowner. That way they can stay in the home and have a proper payment they could actually afford instead of going through foreclosure. These screenshots are very, very damning to the banks. They are very afraid of them because of all the different fraud implications that come about by looking at this Bloomberg terminal. Now, the next couple pages that you're going to look at will be description pages of the actual class and groups of the trust. Okay.
Keep in mind that this is a older presentation. These video these screenshots can look a little different case by case. Keep that in mind that the software, the third-party software does evolve over time. Just keep that in mind moving forward. But he did mention something very interesting there, where the financial companies, can be afraid of the information, right? So, that's one of those things, right, where the attorneys or whoever is using the reports, obviously using them as leverage to put pressure on the other side to try to get a positive outcome for the client, and that's really the one of the most important uses of the report. Now, obviously, I've heard of stories of big cases. I'm happy to hear the stories. I'm happy to hear our clients contact us and tell us. Makes me very happy. There's interviews of those people you can watch online. But keep that in mind, and that's a very important aspect of the report. Okay, yes, is parts of it technical? Yes. But just keep in mind the main parts of the report. What is the report doing? It's putting pressure on the other side to try to get the situation resolved or try to get a positive outcome for the client.
You'll be able to see what the original issue number was as far as dollar amount, what the current issue is as far as dollar amount goes. The most important part of these next two pages will be this grayed out box here in the bottom. Now, a lot of court systems definitely fraud upon somebody bringing fraud upon the court. And what this shows you is that this trust is still actively performing to current date, meaning that every loan in the trust is still also actively performing.
Keep in mind that these can still, again, the way you're seeing it with the gray box and the stuff he's saying, it can be different now because, again, the software and the screenshots, they can evolve a little bit over time, again, because the software is a third-party software. Okay, just keep that in mind.
So the foreclosing trustee, by bringing the foreclosure action upon the homeowner in the first place, is doing so because they state that they're the holder in due course of the note. Without actually being the note holder, they do not have the right to sale. This will prove that the loan is still actively performing in the trust. The loan or the note cannot be in two places at once. So that shows you the tangible fraud has been brought upon the court on behalf of the foreclosing trustee. Now, the next page is basically going to be the collateral characteristics of the loan. Basically what this is, what's inside the trust itself. Okay, it's going to tell you what types of loans are in it, whether they're conventional or subprime, whether or not they're first lien or second mortgage types of loans, adjustable and fixed rate mortgages, so on and so forth. Now, the last page that you're going to look at from the Bloomberg terminal is going to be the 8K filing and the prospectus filing. Now, this is one and the same as the prospectus that was highlighted at the beginning part of the report. This is just a direct screenshot from the Bloomberg terminal reflecting the prospectus being the same as the one that was accepted from the SEC website. Now, the next page is going to be a graphic that shows